Hello everyone, very good afternoon and welcome back everyone to your favorite channel, that is StudyIQ IAS English, and I'm your educator Praveen Mishra, and we are going to start today's marathon session for our Polity current affairs, right? That should be ranging from January to March 2025 as prelims is approaching, right? So we have got not almost even, exactly 8 days from here in our prelims, right? So it's time for us to have the top gear of revision, and from the perspective of current affairs, we know it very well that no one can ever be very much sure, no one can ever justify that this is the last level, this is the last mark of current affairs, right? Because if someone says this particular statement, either the person is himself or herself is very much innocent, or maybe considering you as very innocent person that can be bluffed or manipulated at very ease, right? So that's not the reality. But what is the reality? What we need to mark is, yes, current affairs is an ocean, a type of a outer space. As much as you explore, it would be going ahead, it would be expanding as much as you can. But the here logic, what we need to understand, we need to have the quality of the content, not the quantity of the content. Okay, the quality as in, obviously the quantity is also here measured, but a type of a quantity which I can grasp, which I can recall easily. This is what the only thing I need to do. So here, this is what we are going to discuss today, is the current affairs for polity, okay, which is also having the quality as well as the quantity mark, right? So when we start with the first one, okay, we talk about, here we go, the first topic for the day. Let's keep it short, simple and crispy, all at same together, okay? So the Supreme Court of India, okay, as per the first thing here, the Supreme Court of India's ruling on forest conservation, right? So yes, the biggest current affairs topic in polity, it is from two different segments, okay? This is what the analysis is since last 10 years, 15 years, etc. Okay, the biggest amount of question or the highest amount of questions in our polity current affairs comes from two segments. Okay, first it is the judiciary, that is the role of Supreme Court, High Court, recent judgments, etc. And second one, it is the acts, right? Acts passed by Parliament, legislative assemblies, etc. Okay, so how much time expected? Dear MD, I didn't got your question there. How much time expected as in, can you please elaborate your question? Okay, how much time as in regarding what? Okay, so here we go. Judiciary, okay, questions related to Supreme Court, High Courts, etc. Okay, these are the questions in the current affairs. And secondly, the acts passed by Parliament or even the legislative assemblies of the states, right? So here we go. The Supreme Court of India has directed the union government and states to ensure that no reduction of forest land takes place without providing compensatory land for afforestation. Okay, so the ruling is part of an ongoing case challenging the 2023 amendments to the Forest Conservation Act of 1980. Before we enter into the features of this particular news, one thing that is to be highlighted here and one thing that is to be noted here as well by all of us is what there is a term known as green grabbing, okay, which has been very much recently into the news, that is green grabbing. Okay, and even before that, talking about the historical context, the historical perspective of the land acquisition system in India. Okay, so when we talk about land acquisition, here we are not dealing with the forest land, guys. Please remember, we are not dealing with the forest land right now. I'm just giving you the backdrop. Okay. For how long this marathon session will go on, just to manage my time. Okay, dear, it shall be around roughly 3 hours, at least 3 to 4 hours. Okay, on a rough note, 3 hours you can keep. Okay, at least, right? So land acquisition. What is land acquisition now? Government is authorized to grab the land of the individuals for the sake of growth and development. So if we go ahead from the historical context, okay, India, when we gained independence, and specifically when our constitution came into being in 1950. So since 1950 till 1978, that is for next 28 years, right to property, okay, right to property used to be a fundamental right. It used to be what? A fundamental right guaranteed under Article 19, Clause 1, Subclause F, and under Article 31, right? But obviously we are a developing nation, right? We are a nation which is developing every single second. So in order to go ahead with the construction, in order to enhance the physical infrastructure, what government needs? Government needs the land. So for that we have got multiple cases, like case reference you can keep the Golaknath versus State of Punjab, IC Golaknath versus State of Punjab 1967. Then we have got the another one, the biggest one here with regard to the land acquisition, through which many of the things in our constitution got changed. That is the Keshwananda Bharti case of 1973, Keshwananda Bharti versus the State of Kerala. And then post the case, post emergency and so on, the Union Parliament passed the 44th Constitutional Amendment Act of 1978 that repealed both of these, that is Article 19, Clause 1, Subclause F, and Article 31 from our constitution, right? Now, this is with regard to the general land. Now we talk about the forest land. Okay, when we talk about this one, the forest land. Can government grab the forest land as well? So answer is yes, it can. And for this we have got a term that is known as green grabbing. Remember, green grabbing. What is this green grabbing? Acquisition of land, okay, acquisition of land or acquisition of literally the forest land, okay, by the government, okay, by obviously the government, could be central or state, for the sake of any infrastructure project, okay. So this is every time in news, right? So this is every time in news, every time as in if you read newspaper daily, okay, so in 7 days you will find these terms or type of these news 3 to 4 days a day, 3 to 4 days a week, for sure, 100%, right? So this is where this particular news has came into being, okay, that is the Supreme Court's ruling on forest conservation. Obviously you know it very well that the biggest trouble that we have right now is with regard to the pollution, and the issue of pollution can be only sorted with one thing, and what is that? With regard to the enhancement of the greenery, environment and ecology protection. This is what simple thing that we need to understand, right? And here is exactly the thing. Supreme Court focuses on afforestation, okay, not the deforestation but the afforestation. Not only Supreme Court, obviously all the other organs, okay, and for the sake of the welfare state's protection, apart from legislature we have got executive, so we have got the judiciary as well. So this welfare state concept should be always kept in mind while delivering any judgment, order or act or ordinance by the legislative organ, okay. And here this is one thing that has been kept into the center of decision, that is what the Supreme Court of India has directed the union government and the states, that is they must ensure what? That no forest or the no reduction of forest land takes place without providing compensatory land for afforestation. So as in if I am taking this much area, okay, if I am taking this much area of any forest, okay, for the sake of any production, for the sake of any project, okay, then the very same area I must be providing back to the forests, as in some other area where I am planting the trees, okay. So this is what the term afforestation here means. Obviously the area where I am uprooting the trees, the very same areas I cannot go ahead and plant up the trees anymore, but yes, some other area maybe near to it or maybe some far place, okay, but I must provide the compensatory afforestation in some other area. And do we have any statute related to it for the sake of compensatory afforestation? Yes, there is a statute related to it. What is the name? Okay, it is the amendment to the Forest Conservation Act, or literally, simply speaking, the Forest Conservation Act of 1980. Okay, that simply talks about the afforestation. Okay, as simple as that. Now, as per the directions of the Supreme Court, okay, as per the rulings of the Supreme Court, what Supreme Court has ruled? No reduction in forest land. Second, linear projects require compensatory afforestation. As in, if forest land is used for linear projects. What are linear projects? Projects such as roads, railways and transmission lines. Guys, remember, the term is very, very important. How do I define linear project? So, linear project is something that is related to the construction of roads, or the application of the railways, or maybe the transmission lines. Transmission lines, obviously the electricity transmission lines. Okay, so this is what is known as linear project. Okay, so for the sake of linear projects, an equal amount of land must be afforested elsewhere. Okay, next, dictionary meaning of forest to continue. Simply what the dictionary has told us. So what Supreme Court has stated? The court reiterated that the definition of forest should remain broad and all encompassing as established in the T.N. Godvarman Thirupalam case. Okay, 1996. So you have got multiple understanding through one such incidence. Now, there is a name, there is a reference to the case. What is the reference to the case? It is T.N. Godvarman Thirumulpad case of 1996, in which a forest, what is basically a forest, was defined. Okay, so what Supreme Court stated? That the dictionary meaning, that is what the general definition of forest was taken into the 1996 case, shall be kept as it is. It should not be changed even through any particular amendment. Okay, so this is what Supreme Court's ruling. Next, as per the amendment, we talk about the amendment to the Forest Conservation Act of 1980. When did this amendment came into being? 2023. And what does this amendment tells us? Firstly, introduced section 1A, okay, which narrowed the definition of forest to two things: declared forests and land recorded as forests in the government records after 1980. Okay, so as per the Forest Conservation Act, amendment to Forest Conservation Act of 1980, which came into being in 2023, the definition of forest was changed. Okay, what is the definition now as per the amendment? Okay, so section 1A came into being, okay, which says the forest that is declared forest only, not those areas which are not declared as forest. And secondly, land recorded as forest in the government records after 1980. That particular land will be only considered as forest which is recorded as the recorded forest into the government records after 1980, which is registered as forest into the government records after 1980. So this is what Supreme Court has stated. No, this amendment is not correct. Okay, and please stuck to the previous judgment only, that is the Godvarman case of 1996, and as per the definition of forest given into that case, we shall be following that particular definition only, and this should be not continued, right? So this is what the petitioners, they have also raised the concern that section 1A will weaken the forest protection by excluding nearly 1.97 lakh kilometers square of undeclared forest land. So 1.97 kilometer lakh, okay, lakh square kilometer. Understand how much big area it is. We will take on Pakistan. This is the area. So this is what petitioner argued, that no, we need to have the certain thresholds, that is with regard to the declared forests and undeclared forests, they should not be here. Okay, we should not be following section 1A of the amendment to the Forest Conservation Act of 1980, and we shall be only following the T.N. Godvarman case of 1996. Okay, so this is where Supreme Court has came into being. Okay, so definition of forest as of now. Okay, what Supreme Court has stated. So what we can see. So Supreme Court's stand on definition of forest. Here we go. Reaffirmed the term forest will continue to have a broad meaning as per T.N. Godvarman Thirumalpad case of 1996. Section 1A has been removed. Second, this means forest land will not be limited to the government recognized forests. Okay, it's not like the only the forests that are recognized by the government will be kept into the consideration. Forest as per the 1996 case, the definition. Firstly, the forest like areas. Second, unclassed forests. Third, community forest lands. So these three shall be taken into the consideration always. This is what the judgment came in the year 1996. Okay, so the court ordered that this broad definition remained valid until all states and UTs complete a consolidated record of forest lands. So in short, let's have a proper the crisp of the whole story. So we have got the Forest Conservation Act. Okay, what we have got? The Forest Conservation Act of 1980. Guys, this is very, very important. Okay, understand very carefully why. Because it is related not just to polity. It is a particular section that is related to environment and ecology as well. So this one particular topic is encompassing through multiple subjects, polity as well as environment and ecology. Simply you can also relate it with geography as well. Okay, or even the concept of agriculture as well, right? So multiple lineage it is having. Okay, so please be very attentive with this point at least. So Forest Conservation Act of 1980. Government introduced the amendment to the Forest Conservation Act in the year 2023. As per the amendment, okay, as per the amendment, section 1 capital A was added, which says a forest shall be considered forest which is classified as in declared forest after 1980. Okay, declared forest after 1980, right? This is what section 1A to the amendment, okay, of the Forest Conservation Act of 1980 is all about, right? Now, as per the petition and as per the Supreme Court's ruling, section 1A is no longer to be used. Okay, what Supreme Court simply stated that section 1A should no longer to be used, and what should be used? As per the T.N. Godvarman case of 1996. Okay, the undeclared, simply unclassified, or even the community forest, okay, they shall all be considered as forest only. This is what the dictionary of the word forest is. Okay, so section 1 capital A should not be taken into usage. As simple as that. This is what simply the Supreme Court's ruling is. Okay, so 2023 amendment that is specifically related to section 1 capital A was nullified. Okay, I hope this is clear. So here we go to the next one. The e-courts mission mode project. See, let's understand the backdrop once again, the background once again. Okay. E-courts. Where are we focusing with this e-courts and what are the major segments to it? Firstly, okay, what do we have right now with us? The Digital India Mission. Okay, what we have got? The Digital India Mission. Okay, as per the Digital India Mission, what we are doing? Obviously, we have digitalized the payment system. Okay, but not just the payment, like for example, we have got the Unified Payment Interface. Through this Unified Payment Interface, very not much in trend anymore, but it was in trend when it was launched. I'm quite sure that very less chances are there that you might have heard about this. It is known as BHIM. Anyone who will say that I have heard about this? Yes, good afternoon guys. Anyone who will say that had heard about this BHIM, that is full form, it's an acronym, Bharat Interface for Money. Any idea guys about this one? Anyone who will say that I have heard about this or I have used this, I have some idea related to this? Anyone with regard to BHIM? No. So there is India's own payment platform. Okay, we have got our own indigenously, okay, payment platform. Okay, like just we have got Paytm, Google Pay, Phone Pay, Amazon Pay. In that very same sense, what we have got? We have got BHIM. It is the government owned platform. Who is owning this platform? It is owned by government. Okay, so you just need to download this BHIM app, register it with your mobile phone, okay, and just like you use Paytm, Google Pay, Phone Pay, etc., this also works like this. So it was launched in the year 2016. Bharat Interface for Money, BHIM. Okay, yes, okay, so just one person has answered. Yes, that's correct, Munna. It is Indian own app, absolutely. Okay, Indian government own app. So just, okay, as you can see, launched in the year 2016, the very same year when we had this demonetization. Okay, so with demonetization, we have also launched BHIM. Okay, but unfortunately not much in trend. Okay, very less people they have been using it. Okay, and as of now, least of the people, I don't think so. Okay, many of the people we would be using it as well. Right. So Digital India Mission. Okay, we have got this Digital India Mission, and through this Digital India Mission, digital payments they have been promoted. And so what else was also promoted? Okay, so what else did we promote it? We promoted the e-governance. Okay, e-governance, that is electronic governance, having the e-panchayats, electronic panchayats, having also the electronic municipalities, that is basically focusing towards the grassroots democracy. Okay, enhancing the grassroots democracy with the help of the electronic system. And yes, finally comes into the picture, we have got also something that is known as that is electronic courts. Right. So remember, all of these e-governance, e-panchayats, etc., they come from where? They come from the Digital India Mission, and one such mode is the e-courts, right? So as what we can see here, the e-courts mission mode project, what it is focusing and how, what are the whole logic. So Cabinet approved the phase 3 of the e-courts mission mode project, and as a part of the National E-Governance Plan. Okay, part of what? The National E-Governance Plan, The e-courts project has been under implementation since 2007. Almost it is going to be 2 decades now. 18 years back it came into being for the first time, e-courts, 2007. So phase 1 2011 to 15, phase 2 2015 to 23, and right now we are having the phase 3. Okay, this is what e-courts. So what is the phase 3 aimed to? Ease of justice by making a shift towards digital and paperless courts through digitization of court records. Second, to provide a seamless and paperless interface between courts, litigants, and other stakeholders, that is other parties involved, right? So that is simply promoting the digital functioning of the courts. Like for example, right now our communication, what we are having digital education, e-education, basically electronic education we are having right now, right? And this electronic education is easing our lives, right? You might be at your comfort zone right now. Either you would be at your home, or maybe you're at your college right now, or you may be in your office or working somewhere. At your workplace you would be also there. So just you are having a mobile phone with you with a digital connection, with a data connection, and now you are able to attend a class. This is what the beauty of the digital revolution is. So when we can have digital revolution in education, right, when we have got now a new type of industry into the segments or sectors of economy, that is edtech, right? We have got fintech, we have got edtech, financial technologies companies, educational technology companies, right? So this is what? Now this is booming the economy. The fintechs, the edtechs, okay, they are providing the bigger hand, a very dominating hand in economic development, billions and billions of dollars. Okay, now the companies, fintech, edtechs, and all this tech companies, basically digital tech technologies, that is, they have become worth billions and billions of dollars. So you can realize the potential and the the type of contribution they would be giving. So in that very same sense, what we have got the e-courts as well. And this e-courts is even older than edtech and fintechs. Okay, we have got it from when? We have got it since 2007. And as per the phase 3, okay, when we talk about the implementation of phase 3. So we have got a department that is known as Department of Justice, which works under what? Ministry of Law. Guys, remember when it comes to e-courts, okay, it is working under what? Ministry of Law, which would release funds to high courts on recommendation of e-committee, and this e-committee shall be constituted where? In the apex court, that is Supreme Court of India. And when we talk about e-committee, it is responsible for policy planning and guidance for implementation of e-court projects. So what are the segments that we need to recall from here? So e-courts, okay, as we can make a map, right? E-courts, 3 phases. Phase 1 from when? 2007, okay, 2007 to 2011, right? Oh, sorry, if it is 2007 to actually 2015. Phase 2, 2015 to 2023, and right now we are in phase 3, exactly from 2023 to we have got 2030. Okay, and as per phase 3, okay, or even simply as per all the e-courts phases, which is the department? It is the Department of Justice. Okay, Department of Justice. This Department of Justice is working under which ministry? So it is the Ministry of Law. Okay, Ministry of Law. As per the Ministry of Law, Department of Justice, there shall be an e-committee. E-committee that shall be constituted by Supreme Court itself. The report of the E-committee shall allocate the funds. The funds to whom? Shall allocate the funds to the respective high courts. Okay. So these are the features to e-courts in India. Okay. So as you can see, guys, one particular topic is providing you insights to multiple topics, right? With this e-courts, now you get to know about BHIM, about the Digital India program, Digital India mission. You get to know about that there are, the e-panchayats, e-municipalities and so on, right? So one topic is going to provide you with multiple of what we say basically the topics or more and more of the insights. Okay. So here we go, talking about the next topic, Foreigners Tribunal. So what is this Foreigners Tribunal? What is the news first of all? Context. While hearing a petition on illegal migrants, Supreme Court has questioned Assam on indefinite detention of declared foreigners instead of deporting them. See, what is the whole news? Obviously, when we talk about the state of Assam, okay, specifically with the state of Assam, right? A particular location troubled or badly impacted because of insurgency, specifically from the state of West Bengal and Myanmar as well, right? So there are many communities in Assam, those who have been living in Assam, but they are not Indians. Literally, they are not Indians. Like, for example, now they are considered exactly Indians. Too much of this controversy happened with regard to their nationality. They are termed as Rajbongshis. Okay. Guys, you can just note down the name. There is a community, okay, on which there was too much of the question that whether they are Indians or not. Okay, whether they are Indians or not. So what is the name of the community? Rajbongshis, Rajbongshis. Okay, as of now, okay, Assam government has declared that is yes, they are indigenously belonging to our country, they are our people, and there shall be no prosecution against them. So literally, just a month back, Assam government dropped 28,000 cases against Rajbongshis into the Assam Foreign Tribunal, okay, into the Foreigners Tribunal of Assam. How many people got freed from the case? 28,000 of them, right, now certified as absolutely original, genuine national Indians. Okay, so this has been the case because of which a tribunal is in news that is known as Foreigners Tribunal. As we can see, established by the Foreigners Tribunal Order of 1964 under Section 3 of the Foreigners Act of 1946. So simply speaking, Foreigners Tribunal is established through what? So one single line, Foreigners Act of 1946. As you can see, it is an act coming from pre-independence era, right? Coming from where? Pre-independence era, right? Purpose: to enable local authorities to refer suspected foreigners to the tribunals. Suspected foreigners. Next, exclusivity to Assam. Something exclusive to Assam. Currently, FTs, as in Foreigners Tribunal, operate only in Assam. Remember, the Foreigners Tribunal, it is active only and only in the state of Assam, while other states handle illegal immigrant cases under the Foreigners Act only, right? So remember guys, a thing that is needed to be marked very carefully, Foreigners Tribunal, right? It is working only and only in the state of Assam and not in other states. Other states, they do have simply the statute, that is Foreigners Act, and through which they do take proceedings into the general tribunals, that is the general cases only. But a special tribunal has been created where only and only in the state of Assam. So when we talk about the composition, so each tribunal is led by a member from the judiciary, simply a judge, an advocate, or maybe a civil servant with judicial experience. Case disposal must conclude cases within 60 days, and failure to provide citizenship can result in detention and eventual deportation. Okay, so the cases in the foreigners tribunal shall be disposed actually in how many days? Not more than 60 days, that is 2 months. Okay, this is what the simple logic is all about. Okay, so I hope this is clear. There should be existing no doubt. Okay, so it is working on the principle of fast track delivery of justice. Okay, guided with obviously the principle of natural justice. Okay, guided with fast track delivery of justice. Okay, foreigners tribunal, and remember, exclusivity, it is only for the sake of the state of Assam. Okay, the other states, they do not have the tribunals as of now, and they simply follow the Foreigners Act of 1946. Okay, so when did this foreigners tribunal came into being? The time period, that is 1964, it is to be marked as well. Okay, so foreigners tribunal, it was not from 1946, it came into being only, if you can see, after 18 years. Okay, but this is what the logic is. It is only in the state of Assam and not others. Okay, so directions issued by Supreme Court. Okay, what are the directives issued by Supreme Court? The court emphasized that once a person is declared a foreigner, okay, they must be deported immediately. As in, today morning I have declared a person as foreigner, by maximum today or tomorrow, maximum tomorrow. That is the time required for the basic preparations, okay, necessity preparations, okay, that is taking the route, transportation, etc. The person shall be deported immediately, right, and cannot be detained indefinitely. If a person is declared foreigner, you are not going to detain him or her, that is keep him under prison like that. No, detain, no, transport, yes, immediately. Next, it cited Article 21 of the Constitution, that is right to life and personal liberty, reinforcing that indefinite detention is literally unconstitutional. Okay, and further, the Union government has been directed to provide total number of declared foreigners in Assam, details of how many have been deported so far, and the procedure being followed for individuals whose nationality is unknown. Just today, what is the date? We have got 17th of May 2025. Just today we have got this news, newspapers, they have told us that Bangladesh has criticized India, that is us, or accused India that Indians, they are not following the proper procedure of law in deporting the illegal immigrants in India from Bangladesh. See, hypocrisy at its best. They are themselves saying that Bangladeshis, they have been living illegally in India. This is what Bangladesh's statement is. And what Bangladesh is expecting us to be, polite and lenient with the illegal immigrants. See, how are you going to justify, or how are you going to, give me the assurance that those illegal immigrants are not terrorists, they are not sleeper cells, they are not the spies and agents of Bangladesh agency, Pakistani agencies, or any other country's agencies. Is Bangladesh or any other XYZ country, okay, ready to provide such type of assurity? Obviously not. And see, this is what hypocrisy comes in. They are expecting us to do what? To provide leniency and follow the procedure. What procedure? Is there any established procedure for illegal immigrants? No. Just they have learnt a word procedure, so they are utilizing the word procedure. This is what the logic is presently with regard to the illiterate Bangladeshi government. This is exactly the reality is. You think Muhammad Yunus is having any rationality? Muhammad Yunus, the caretaker, so-called caretaker of Bangladesh. Bangladesh's government actually, right? So have learnt a word somewhere out of nowhere, don't know, procedure, and now they are stating procedure follow nahi kiya, right? What procedure? Okay, so this is where Supreme Court has guided. Okay, this is what is known as procedure, right? The guidelines, the directions, okay, the protocols that is issued by whom? By the government as well as the judicial organ of the country, right? Okay, so next, the draft digital personal data protection rules of 2025. Okay, so the next topic here for our discussion, draft digital personal data protection rules. What time period? 2025. Context. The draft digital personal data protection rules released by MeitY. Okay, please make the full form clear because this is the name you are going to encounter, okay, multiple times in today's session only. MeitY, full form, Ministry of Electronics and Information Technology. Okay, Ministry of Electronics and Information Technology. This is in short MeitY. Okay, so what is the whole news? Criticism. Criticism to the draft digital personal data protection rule. So appointment of the DPP members. So the Union government has the discretion to appoint the members to the DPB, raising concerns over the separation of powers and the independence of the body since it's perform quasi-judicial functions. Second, its dispute resolution mechanism, in short DRM. Appeals from the DPB's decision will be filed before the Telecom Dispute Settlement and Appellate Tribunal within 6 months, which is seen as an unrealistic, okay, given the current workload and capacity of the tribunal. So as per the draft digital protection rules, okay, as per the digital protection or the personal data protection rules of 2025, what the criticism has been given to us, okay. Criticism is to, first of all, the transparency in the appointment of the members. Okay, what is that? Transparency in the appointment of the members. And secondly, the dispute resolution mechanism. Will the time period of 6 months be sufficient enough given the present workload of the tribunal, that is TDSAT? What is TDSAT once again? The Telecom Dispute Settlement and Appellate Tribunal. Okay, so the two concerns what we have got, okay, is it really the correct criticism? Is it really a thing which will be, troubling the sector, or is it just simply the criticism? Okay, so this is what we shall be taking into the consideration. And now here comes the demand for institutional reforms. Okay, as we can see, specialist appointment. A technical member with expertise in data protection should be appointed. And guys, remember, in Justice K.S. Puttaswamy case, keeping this whole big thing in short, okay, in Justice Puttaswamy versus Union of India case 2017, the Supreme Court directed, okay, the Supreme Court directed, what is that? Right to privacy, right to privacy is an intrinsic part of Article 21, that is right to life and personal liberty. Okay. This is simply the scenario. Okay. That is, right to privacy is an intrinsic part. Intrinsic part of what? Intrinsic part of Article 21. That is right to life and personal liberty. Okay. So, as per the draft or the as per the new rules of the data protection, okay, what is required? A specialist, okay, a specialist is required, that is a technical member with expertise in data protection should be appointed into the Telecommunication Dispute Settlement Tribunal, TDSAT, okay, since data protection issues are distinct from telecommunication matters. And next, amendment to section 14C of the TRAI. What is TRAI? Telecom Regulatory Authority of India. Okay, so guys, remember this TRAI. Okay, what is this TRAI? Telecom Regulatory Authority of India. Okay, so section 14C of the TRAI Act is required to accommodate this particular change, as in to have a specialist into the tribunal, specialist related to the data protection. Okay, because data leak is the biggest problem what we are facing right now. Okay. So, here we go. Next one. Automated Permanent Academic Account Registry, APAAR ID for school students. Okay. The next topic, what is it? APAAR, Automated Permanent Academic Account Registry. It is what? An ID. ID for whom? For school students. Okay. ID for whom? ID for school students. As in, when we talk about the APAAR, just like we have got Aadhaar card, just like what we have got PAN card, okay, and APAAR ID is to be given as well. So, what is the context? Parents and activists fear that opting out of the Education Ministry's APAAR ID for school students could become impossible despite enrollment being officially voluntary. Okay. But firstly, what is about APAAR? What are the things about APAAR? So, it is an initiative of obviously Ministry of Education. Came through which policy? National Education Policy of 2020. Okay. Now, what are the features to it? Okay. What will APAAR be guaranteeing? So, it shall be a lifelong academic identity. Okay. Lifelong, from your school to your college to further academics. Okay. Each student gets a unique 12-digit ID. And remember, it is absolutely digit. ID numbers, they are of two types basically. Okay. Like for example, your Aadhaar card. Okay. Simply, we talk about the Aadhaar card. So, Aadhaar card is what? Absolutely having only and only the digits in it. Aadhaar card do not have the alphabets in it. Right. But the PAN card, it is alphanumeric, having the alphabets as well as digits. Right. So, in that same sense, APAAR is what? Alphanumeric? No. APAAR is not alphanumeric. APAAR is digit, only and only numeric in nature, having no digits inside. Right. So, how many? 12, just like Aadhaar card. How many numbers we have got in Aadhaar card? 12. Okay, in that very same sense, APAAR. Then, centralized system manages academic records at one place. All your academic records. For example, what we have got? We have got the DigiLocker. Okay, APAAR works exactly on the same lines of DigiLocker. If you have ever used DigiLocker, you must be aware that how convenient this thing is. Your digital locker, okay, that is authorized by government. Remember, this is DigiLocker, which is authorized by government. that is the guarantee of the data stored inside DigiLocker goes into the hands of government, central government. Okay. So in DigiLocker, you can store all of your documents from your Aadhaar card, PAN card, voter ID, passport in digital format, and you can access it from anywhere. And now, how am I going to guarantee the DigiLocker? So DigiLocker is authorized by UIDAI. UIDAI as in Unique Identification Authority of India. Okay. So when I am accessing DigiLocker, I need to enter my mobile number. Then an OTP will come, and this OTP will be empowered by the UIDAI department. That means it will be coming from the Aadhaar card's perspective. And then only I will be able to access the DigiLocker. And the DigiLocker's safety is into the hands of government, central government. So in that very same lines, on the very same lines, we have got the APAAR. Okay. So centralized system manages academic records all at one place. Next, credit transfer. Facilitates the transfer of credits between the institutions. Let's say, for example, the scholarship. Okay. So for scholarship, obviously students, they have to, get in lot of trouble. Documents, beneficiary adding, account verification, etc. Many of the things are there. Okay. So with APAAR, it shall be justified in one click. Then lifelong identity obviously stays with the student throughout their educational and even the professional career. Okay. So this is what the logic of APAAR is. Okay. Now, as we can see, the registration process, where the concerns they have risen. So firstly, the parental consent. Due to the sensitive nature of personal data involved, parental consent is required for the student below 18 years. If you are a student above 18 years, then obviously not. But yes, if below, then it is required. Second, parents can obtain and submit the consent, okay, through their child's school or the official APAAR website. Right? So this is what can be done. Okay. APAAR ID generation. Upon successful registration and verification, the system generates a unique 12-digit APAAR ID, which is then linked to the student's DigiLocker account for secure access. So this APAAR, I can access this APAAR from where? I can access this APAAR from my DigiLocker account as well. Okay. So just like DigiLocker, APAAR also helps me. Right. Okay. Here we go. The next one. In-house removal procedure for High Court judge. What the world has witnessed, or world, let's forget the world, not forgetting the world, sorry. Let's discuss about India. What we as Indians we have witnessed, what we as Indians we have encountered. A judge in the High Court, his name is Sanjeev Khanna. Okay. A month or 2 months, basically, it has been now around 2 months back, what has happened, that his house was burning. Not his house actually, one of the room, type of a outhouse in his official residence was burning. So immediately the fire department came in, okay, the fire brigade came in, and what they found? They found lakhs and lakhs of currency being burnt. Unfortunately, the whole currency didn't got burnt. Okay, just some of the currencies were left. They were still burning, and this news came out. Obviously, this represents Justice Sanjeev Khanna's, not Sanjeev Khanna, sorry, Yashwant Khanna. Okay, Justice Yashwant Khanna's, or sorry, Justice Yashwant Verma's corruption. That he is a corrupt judge, right? Obviously, some sort of corruption is there. He has gained money through not legal means. He has earned money through not legal means. But what has happened? Was any action taken against him? Yes. You know what? He was transferred from Allahabad High Court to Delhi High Court. Okay, this is what action was taken against Justice Yashwant Verma. is it really the delivery system of judiciary? Is it really the justice we need to serve? So, as per the Judges Inquiry Act and as per the judgment of 1999, okay, as per the case of 1999, if any such case is highlighted in front of the judiciary regarding the misconduct of judges, okay, then immediately the removal procedure doesn't start. What starts is an ICC, that is Internal Complaint Committee, that is simply speaking in-house, okay, in-house inquiry, okay. So as per the case, if we just go ahead and discuss the case, the in-house removal or the in-house inquiry for the High Court judge. So Justice Yashwant Verma of Delhi High Court, okay, found with lakhs of currency being burnt at his place. So first of all, as per the Indian Coinage Act of 1948, forget about corruption, okay, simply forgetting about corruption. As per the Indian Coinage Act of 1948, we've got a Currency Act, okay. Destruction of currency, destroying the currency is also a punishable criminal offense, right? So forget about misconduct. Justice Yashwant Verma should have been prosecuted because he was destroying the Indian currency, burning the Indian currency. But unfortunately, no one even mentioned this act. Literally, no one bothered even to mention this act, that there is also an act which shall be taken into the consideration, right? Burning of the currency, okay. So about in-house removal process, initiation of the complaint, okay, after the complaint has been received, okay, received by whom? It should be either of the three. Who three? Firstly, President of India, secondly, the Chief Justice of India, and thirdly, the Chief Justice of a High Court. If any of them have received a complaint against a judge regarding what? Regarding misconduct. Regarding what? Regarding misconduct, okay, then only an in-house, not removal, in-house inquiry shall happen, okay. The CJI decides whether to proceed or dismiss it, okay. Now, preliminary examination. If needed, the CJI seeks a preliminary report from the concerned High Court Justice. Then, formation of the inquiry committee. If the preliminary report recommends further action, the CJI forms a 3-member inquiry panel consisting of 2 High Court Chief Justices and 1 High Court Judge. Okay. So, how many members they shall be there in an in-house inquiry committee? So, there should be 3 members. Okay. How many? Exactly, once again, 3 members. And who shall be these 3? High Court Chief Justice, one more High Court Chief Justice, and 1 High Court Judge. Any, okay, any, right. So, Justice Yashwant Verma, he was serving in Delhi High Court, right. So, Justice Yashwant Verma, where he was serving in Delhi High Court. So, it is not mandatory to have, the judge from Delhi High Court only, or High Court from Delhi High Court only, or Chief Justice from Delhi High Court only. It could be from anywhere, okay. So, before the retirement of the former Chief Justice of India, Sanjeev Khanna, he retired on 13th May. Exactly, it was, I believe, 7th or 8th of May, probably before that, 6th of May probably, when the in-house inquiry committee submitted its preliminary report, okay. But Chief Justice Sanjeev Khanna, he retired very soon on 13th of May. Okay. Now we have got the new Chief Justice of India, B.R. Gavai. So let's see what will be the action in case if it is taken against the judge or not. Okay. So but as of now, the in-house inquiry committee, it has submitted its report, but so far no such investigation has been further taken on. Okay. So as per the formation and so on. So committee's powers and procedure. What are the powers the committee possess? The inquiry panel can devise its own process, ensuring natural justice. As in, simply speaking, giving the accused judge chance to defend himself or herself. Okay. So, are the allegations substantive? That is, are they right? First of all. Second, if yes, do they warrant removal proceedings? So, two things. Are the charges on the judge fair enough? That is, right enough, firstly. So, secondly, even if the charges are fair enough, then is the mistake or the action or the conduct of the judges so grave that it should be leading into the removal? Okay, so these are the features, okay, as per the Internal Inquiry Act. Okay, internal inquiry of the judges. So further, possible outcomes. If allegations are not serious enough for removal, the CJI can advise the judge or place the report on record. And if allegations are serious enough for removal, the CJI will advise the judge to resign or retire voluntarily. Okay. And final step, if the judge refuses to resign, in case, the CJI will instruct the concerned High Court Chief Justice not to assign any judicial work to the judge. The President and the Prime Minister will be informed for the impeachment proceedings. And in Justice Yashwant Verma's case, CJI has already directed the Delhi High Court Chief not to assign him any work. Okay. But in that meantime, you know what has happened? The judge was transferred. So right now the judge is in Allahabad High Court. Working well, took the oath, okay, going to the court, working, okay, nothing has happened, okay. So next, repeal of the Dramatic Performance Act of 1876, okay. So next what we have got, repeal of the Dramatic Performance Act of 1876. Context, okay, what is the news? Recently, Prime Minister Narendra Modi highlighted the importance of deleting obsolete colonial laws, mentioning the Dramatic Performances Act, which was officially abolished in 2018. See, still right now, after 78 years of independence, still after 78 years of independence, what do we have with us? There are many laws which we are following. They are coming from the British rule era. Okay, they are coming from which era? From the British rule era. There are many laws. Like for example, the Companies Act, the labor laws, the Hindu Marriage Act, okay, or even till last year, we used to have the IPC, okay, that is Indian Penal Code, which came into being in the year 1860. Though the Constitution allows the working of the pre-constitutional laws under Article 13 and 372, but that doesn't means that we shall be continuing with the, erstwhile or the British rule era, the British era laws, right? So far, there are many laws which are still being used, but there are many laws which we have considered null and void as well, that is obsolete as well. They have been considered obsolete as in no longer in use. So this is what has come into the news here. While addressing a speech, Prime Minister Modi mentioned the Dramatic Performances Act of 1876, which is repealed. What Prime Minister was referring? He was referring that there are still many laws coming from the colonial era, and that shall be repealed as well. Okay, that shall be repealed as well. So here we go. Repeal of the Dramatic Performances Act 1876. So the law gave the British government powers to prohibit public dramatic performances that were scandalous, defamatory, seditious and obscene. Literally, it allowed authorities to ban any play, pantomime or drama that was deemed to excite disaffection against the government, deprave and corrupt the audience. Simply speaking, just like present day Instagram. Okay. Yeah, good afternoon, sir. Prince, dear, I can't explain in Hindi, dear. Okay. As it is absolutely the English channel. Right. It is absolutely the English channel. Right. So as you can see the name of the channel, it is StudyIQ IAS English. Right. So this doesn't allows us to have discussion in any other language rather than English. Okay, so I'm really sorry for it. Okay, can't be helping anything in this. Okay, so rather than English, no other language is allowed here. Hindi, Marathi, Bengali, Kannada, Tamil, Malayali, nothing. Okay, so I hope this is clear. Right. So just like what we have got presently, Instagram or YouTube, okay, or we have got other social media platforms. There, if you are posting any content, okay, there if you are posting any content which is derogatory to the dignity of an individual, a group of individuals, that is basically community, organization, nation, defense, etc., that is not permitted. That is literally not permitted. In the very same sense, erstwhile what we had this Dramatic Performances Act of 1876, and as per the Dramatic Performances Act of 1876, any dramatic act performed in public which excites dissatisfaction against the government, okay, which is considered, very much aggressive against the government, shall be banned. Okay, so this is what the Dramatic Prohibition, okay, or the Dramatic Performances Act of 1876 is all about. Okay, presently we have got multiple acts, like for example, we have got section 69 capital A of the Information Technology Act. We have got Article 79 with regard to the same Information Technology Act. We have got Article 19, Clause 2, Clause 3, Clause 4, Clause 5 that talks about the reasonable restrictions to the fundamental rights. Okay, this is what. Sir, when we get Geography Marathon, dear Naveen, stay tuned with the channel. Okay, on the community posts, you shall be having the update quite soon. Okay, by today or by tomorrow, you shall be having the update that exactly when we shall be having the Geography Marathon. Okay, right. So, repeal of the Dramatic Performances Act of 1876. Okay, so what do we have as per the law, as per the rules? Okay, what was there? So it allowed authorities to ban any play, and further, okay, it can issue search and seizure warrants. Apart from that, it can also arrest the individuals. So what was the punishment? The act prescribed a jail term of up to 3 months, including a fine or maybe both. And why was this law enacted? So it was enacted after the visit of Prince of Wales Albert Edward to India in 1875-76, and it was part of a series of colonial laws aimed at suppressing nationalist activities. Okay, at the very same time period, we had another draconian law that was known as Vernacular Press Act. Okay. So on the very same lines of Vernacular Press Act, we had got what? The Dramatic Performances Act. Right. So, repeal of the Dramatic Performances Act of 1876. What it is here. So, the present government has launched a flagship initiative to repeal obsolete laws, okay, which helps to improve the ease of doing business index. As of now, our ease of doing business index, what it is telling, we are below the rank of 60, and around 2 decades back, we used to be into the ranking of 130, 140 plus. Right, but right now our ranking in the ease of doing index globally has drastically upgraded. Okay, right now we are less than 60. I guess I'm not so sure exactly with the rank, but we are less than 60. Okay, between 55 to 60 is what our ranking is presently. Right. So, why do colonial laws continue to exist? As per Article 372 of the Constitution, which states that laws in force at the time of independence would continue unless repealed or modified. Okay, what will happen? Okay, Article 372, what it says, that laws in force at the time of independence, that is 1947, whatever the laws they were being present at the time, they shall continue to be in operation until and unless they are either repealed or modified. Okay, so this is what Article 372 empowers. So next, what we have got? Advocates Amendment Bill of 2025. Okay, what is this? It was withdrawn recently after facing opposition, okay, from the legal bodies. And what is the objective? Okay, the Law Ministry sought to amend the Advocates Act of 1961 to address contemporary challenges in the legal profession. To address what? Contemporary challenges in the legal profession, aimed to align Indian legal practices with global standards and accommodates changes in the legal sector. Okay, so what is the whole logic? We need to understand it's about the Advocates Act of 1961. See, one thing that I must make very clear. We have mentioned here multiple bills, okay, just to get this outcome, that is the proper act. Listen to me very carefully. You are never going to receive or encounter any kind of question, neither in your prelims nor in your mains, related to a bill. Okay, the bills are never asked. Only the acts, that means only the bills which have been converted into a law, will be there into the question. But yes, because of these bills, many of the existing acts, they do come into the picture once again, into the current affairs pictures again, right? So in order to come to this conclusion, that is the proper act, we have mentioned here bills. But don't worry, you need not read bills. Okay, there are thousands of bills still pending in Parliament, in legislative assemblies. Okay, how many are we going to read? And firstly, it is not even part of the syllabus. So bills are not mandatory for us. What is mandatory for us? They are the acts. Okay, so here through this Advocates Bill, okay, we have got the Advocates Act of 1961. As per the act, it is the primary law that governs the legal profession in India. First of all, it provides for the regulation of advocates, formation of the bar council, okay, at the national and at the state levels, and also talks about the ethical conduct of advocates. And section 4 establishes the Bar Council of India, which regulates all the legal profession as well as legal education. Okay, so remember, Advocates Act of 1961, okay, through which all the legal education and profession is handled. The very same act talks about the establishment of the bar councils at the central, that is at the union, and at the state level as well. Okay, so key controversies of the bill, not much to be discussed, nothing more important here. Okay, So here we go. UGC's draft regulation. What is UGC's draft regulation? So UGC, as in the University Grants Commission, has issued draft regulations aimed at redefining discrimination and explicitly introducing the term caste-based discrimination in university campuses. Okay, so just understanding the background of the story. Just a couple of months back, okay, just couple of months back, a report was given to us, a report was highlighted in front of us, which talks about the students' suicide in one of the most elite and prestigious institutions of our country, that is known as IIT Delhi, Indian Institute of Technology, Delhi. Between 2018 to 2023, okay, between 2018 to 2023, many suicide cases they have been marked just in IIT Delhi. Okay, many as in, I'm not so sure with the figures, but yes, the figures, they were devastating. Okay, like around 30 plus students between 2018 to 2023, just in IIT Delhi, they committed suicide. As per the initial findings, as per the prima facie investigation and the inquiry, okay, it just actually represented that 1/3 of the suicides, they happened because of the type of the academic pressure, okay, or if not academic pressure, then some personal reasons. The 2/3 of the suicide reasons, they were the caste-based discrimination, okay, caste-based discrimination, where inside elite institution, IIT, and that to IIT Delhi. We talk about the top IITs, so we have got IIT Delhi, IIT Mumbai, IIT Kanpur, right? We have got many IITs, but when you talk about top 3, so IIT Mumbai, IIT Delhi, IIT Kanpur, these are the top 3 IITs. And in IITs of India, simply Indian Institute of Technologies, why students are committing suicide? Because in such an elite and powerful institution, the students are facing the caste-based discrimination, right? So in order to get rid of such things, UGC's draft regulation, it came in and it talked about, okay, firstly, okay, the things, okay, as in to eliminate all the level of caste-based discrimination, firstly, and secondly, to provide a grievance redressal mechanism and a particular hotline, a helpline for the students inside IITs, so that with the help of those helplines, with the help of those support system, the students, they are able to get the proper counseling, get the proper mental and emotional support they need, and apart from that, any other type of just elimination of the issues or the problems could be made possible, right? So this is where UGC came into the list here. This is where the UGC came into the picture here, considering the conditions of students in the elite educational institutions of our country. Okay. So, sir, can we get this PDF? Yes, Naveen, surely dear, you can join my Telegram channel, okay, and you can surely get this PDF, okay, right? So, here we go. Epic in electoral roles. Okay, what is this epic? So epic, first of all, is the epic that is related to the legendary stories, that is also epic. Okay, but here is epic different. Full form is electronic or elector's photo identity card. Also we term it as electronic photo identity card. Now a fun fact, okay, a very interesting fun fact for all of us. Okay, what is that? Epic as in simply your voter ID card. If you have your voter ID card with you, I suggest you just open up, okay, get your voter ID card if you are having it with you right now. And one thing, all the ID cards, okay, literally all the ID cards from your ration card, passport, Aadhaar card, or even a PAN card, right? Whatever ID you have got the driving license, they are all issued by, okay, they are all issued by, all of them, by the government, okay, either by the union government or by the state government. All of those cards, they are issued by the government. But Epic as in voter ID card, okay, simply talking about Epic elector's photo identity card or the voter ID card, it is issued by not the government. It is the constitutional body that is known as Election Commission. I bet you just open up your voter ID card and you will never find nowhere the word Government of India or your state government would be mentioned there. Just one organization is mentioned there in your voter ID card, that is known as Election Commission. Government is not mentioned there. What is mentioned? Election Commission is mentioned there, because it is the only ID, okay, the voter ID, it is the only ID which is mentioned, which is granted or which is issued to you by the Election Commission of India. Rest all the other IDs, okay, it is given to you by whom? Either by your state government or by the central government, okay, always, right? So this is what the story for voter ID card is, okay. So here is the context. Recently, West Bengal's Chief Minister raised concerns over duplicate electors' photo identity card. Okay. So this is where Election Commission has stated that don't worry, now we have got the AeroNet with us, and this AeroNet, there is a particular organization we shall be discussing, which will be eliminating all such duplication of the voter IDs. Okay. So what are EPICs? Electors Photo Identity Card and Identification Document for Voters. Came into the picture when? For the first time in 1960. Remember guys, when it came into the picture in 1960s. Okay. Now, and issuance began when? Into the 1993. Okay. So, through the act known as Registration of Electoral Rules of 1960, and the issuance started when? Through the 1993 time period. Okay. Now, what are the features to the EPIC? Obviously, issued only to the registered electors. Does not grant the right to vote unless the holder's name appear into the electoral roll. Remember this thing. Just because you have the voter ID card doesn't mean you are eligible to vote. Okay. Remember this thing, just because you have got the voter ID card doesn't makes you eligible to vote. How you are made eligible to vote? Only when you have registered yourself into the electoral roll of your constituency. Okay, please be very sure guys that don't go to vote just because you have got the voter ID card. Okay, after your voter ID card has been issued, okay, you need to register yourself with the electoral roll. You need to visit the nearest electoral office. You need to visit the nearest electoral officer, okay, and ask him or her to register your name as an elector into the electoral's roll. Then only you will be able to cast your vote. Okay, just simply because you have voter ID doesn't make you eligible to cast vote. Okay. Next, What does it contains? Your name, okay, obviously, along with age, and yes, it provides your proper address along with your photograph as well as signature. Okay, so remember, voter ID card is one of the most powerful voter IDs or the epic cards. Okay, so what are the features? It is having a unique number consisting of 3 alphabetical codes followed by 7-digit number. So literally how many 10 digits are there, in which 7 are numbers, 7 are actually digits and 3 are alphabets. So it is what? Once again, alphanumeric, just like your PAN card. Okay, just like what? Your PAN card. It is alphanumeric. Okay. Now it is having a fusion as in functional unique serial number for each assembly constituency. So in your alphanumeric ID number, you will be also having an FUSN. What is FUSN? Functional unique serial number, okay, which shall be mentioning your constituency. Remember, this alphanumeric number will be your ID card's number, but FUSN, as in functional unique serial number, will be having your assembly constituency's number. Okay, that is the digital code or simply the code for your constituencies. Like for example, if you have given any competitive examination, okay, then while filling the OMR sheet, you fill your roll number and then you also fill the center code, right? While you are filling your roll number, you also fill your center code, right? So that center code is exactly the FUCN, that is functional unique serial number. Okay, FUSN. What is it? It is the code for your assembly, that is code for your constituency simply. Okay. Now, in order to eliminate such type of duplication or just type of the artificial voter ID cards, okay, the Election Commission has got what? AeroNet. Okay, they have created an AeroNet system that shall justify the issuance. Okay, issuance of what? Issuance of the epic numbers. Okay. Next. So here we go. OSMA, Online Assurance Monitoring System. What is this? Recently, the Parliamentary Affairs Minister informed that 99% of the parliamentary assurances have been fulfilled, and OAMS has helped ensuring that these assurances get fulfilled. Okay. So what is the context? Who and what has been stated? So Parliamentary Affairs Minister informed what? That 99% of the parliamentary assurances, they have been fulfilled, first of all. Okay. And it has been helped, okay, because of what we have got this data. We have got this data because with the help of OAMS. And what is this OAMS? Online Assurance Monitoring System. Okay, guys, remember the full form. OAMS, Online Assurance Monitoring System. Okay. Now, what is this OAMS, Online Assurance Monitoring System? It is a digital platform implemented by the Ministry of Parliamentary Affairs in collaboration with the Lok Sabha and Rajya Sabha secretariats. Remember, it is not Lok Sabha and Rajya Sabha. It is Lok Sabha and Rajya Sabha secretariats. Okay. Launched when? 2018. What is the name? Online Assurance Monitoring System. Next. Aims to track, monitor and ensure the fulfillment of assurances given by the union ministers in parliament. Simply speaking, what does it tracks? What does it helps in tracking? So obviously, when we talk about the democracy, so the biggest gift of democracy is what? The accountability. and the transparency of the government, of the office bearers. Remember, the most beautiful thing about democracy is what? It is the availability of elements like accountability and transparency. Okay. So, wherever we have got these two things, democracy is functioning quite well. And in order to strengthen these two things like accountability and transparency, many actions they have been taken. And one such action is this OAMS, that is Online Assurance Monitoring System. So, whatever the union ministers they have assured inside the parliament, that is they will be doing this, doing that, etc., etc. Okay, it shall be stored, okay, where? Into a digital repository that is simply known as OAMS, Online Assurance Monitoring System, and their actions will be monitored, and once the actions they are completed, it shall be marked as tick into the OAMS, right? So this is what Online Assurance Monitoring System is all about. Okay, so the key features: it will be having a digital repository, stores all parliamentary assurances in centralized databases, eliminates the risk of losing or overlooking commitments, and further, automated alerts and notifications, simply sends timely reminders to relevant ministers and departments, simply helps maintaining the adherence to deadline for fulfilling assurances. Simply speaking, one line, it is helping in accountability, right? Simply doing what? Helping in accountability, right? So when a minister has made any assurance, this assurance will be tracked, monitored and alarmed to the minister as well कि भाई वादा कर रखा है, कर लो complete. That dude, you have promised something, please do it. Simply maintaining the transparency as well. Okay, so when we talk about ministerial assurances, okay, simply talking about the ministerial assurances. During the course of answers to questions or during debates, various assurances in the form of promises, undertakings or other such forms of expressions are given by ministers on the floor of the house, right? Such assurances are given due to non-availability of information at that point of time to meet the questions or points raised by the ministers. So simply when we talk about the tools of the parliamentary proceedings, okay, simply talking about the tools of the parliamentary proceedings. So we have got the question hour, okay, question hour as in this is the first hour of every parliamentary meeting, okay. Every day, the first hour, it is termed as question hour, and there 3 types of questions are asked from the ministers. So the first one is the starred questions, that is followed by an asterisk mark, okay. Then comes the unstarred questions, okay. Then comes next the unstarred questions, okay, no asterisk mark. And then comes the short notice questions. So the starred questions, they are to be answered orally and they can have supplementary questions, okay. Next, unstarred questions, okay, they are to be answered in written and literally no supplementary questions, okay. Short notice questions, once again written, and since they are written, once again no supplementary questions can be followed. So while answering, okay, such things, the ministers, they often make what? they make the promise, also some undertakings. Okay, simply speaking, assurances. And to keep a track on these assurances, we have got the online assurance monitoring system, OAMS, continuing since when? Since 2018. Okay, guaranteeing what? Okay, it is guaranteeing what? It is guaranteeing the, first of all, transparency, as you can track the actions of the minister there, as well as obviously followed by accountability. Okay, so this is where these two things, they are always coming together with one. Okay, so we have got the committee on government assurances as well. How many members are there into the committee? 15 members from Lok Sabha and 10 members in Rajya Sabha. So independently the OAMS, the assurance committee works. Okay, so it consists 15 members in the Lok Sabha. When it comes to the Rajya Sabha, it is having 10 members. Okay, so the proper committee is there. Working under which ministry? Remember guys, the name of the ministry is also very important. It is the Ministry of Parliamentary Affairs. Okay, so make it clear that you name the ministry as well. What is the name of the ministry? Ministry of Parliamentary Affairs. Okay, next. Section 79, Clause 3, Subclause B of the Information Technology Act. What is this? Every particular information technology department or every particular information technology organization, from the digital or the social media platforms or any other. Simply speaking, if I am a digital media platform or a social media platform, I am bound by the government rules to follow some government rules. And in that comes one, Section 79, Clause 3, Subclause B. What it says? It provides the safe harbor to the intermediaries. So there are three things, okay, that is to be noted. Firstly, the user. Secondly, the portal. And thirdly, the government. Okay. So whatever I am posting on my social media, as per Section 79, it is me, that is the user, who is held responsible for any post on my social media, and it is not, literally not, the intermediary, that is the platform. Okay, as in whatever right now we are communicating through YouTube. Okay, so I am teaching. So whatever I am teaching to you, I am responsible to all of my words, all of my the actions and all of my teachings. It is not YouTube. YouTube is just providing us the platform to connect. Okay, this is what the safe harbor is. If I have stated something wrong, something vulgar, something inappropriate, something which is not good enough related to the dignity of an individual or a group or something, so it is me who is responsible. It is not the platform, right? So this is where Section 79, Clause 3, Subclause B comes in. Okay, of what? Of the Information Technology Act of 2000. Okay, so what is the case here? What is the whole news here? Elon Musk, the owner of Twitter, now X. Okay, Elon Musk, who owned the X, that is now formerly the Twitter, has challenged the Indian government's use of Section 79, Clause 3, Subclause B of IT Act 2000 to moderate and remove content on social media. Couple of months back, 2 months back, this was in too much of trend. The AI of X, that is known as Grok, which was providing very much misinformation, literally misinformation related to Indian government as well as Indian administration. So, country of India as well as its administration as well as government. Many of the misinformation was provided by this AI that was named as Grok. Okay, so what is Grok? The AI of Twitter, that is X. Like for example, if you are using the Samsung Android, not all the Android, if you are using a Samsung Android phone, then you have got an AI with you that is known as Gemini, right? Or if you are using Apple, then you have got an AI with you known as Siri, or generally we have got an AI ChatGPT. So in that very same sense, Twitter, that is X, has also got its own AI that is known as Grok. Now, Grok was providing very much misinformation and an information which was also derogatory in nature. Okay. So then Indian government asked the Twitter portal, okay, to just remove all the user content related to Grok on the platform, for which Elon Musk stated that this is not correct action by the government. Okay, so now what he quoted section 79, specifically clause 3 subclause B, and now what it is. So section 79 of the Information Technology Act provides safe harbor. Provides what? Safe harbor, that is protection to intermediaries such as a social media platform, search engines and other internet service providers. Safe harbor protection, what it is? It is a legal framework that shields intermediaries, that is social media or other platforms, from being held liable for the content uploaded by their users as long as they comply with some certain conditions. Okay, so let's say here is the user, okay, and here is the platform. Platform, it could be any, okay, it is YT, it is Instagram, it is Telegram, okay, it is any, it is X, it is Facebook or whatever. Okay, so whatever the user has posted, okay, whatever the user has posted, okay, any user of any platform, who is to be held liable for that post? It should be only and only the user who shall be held liable for the post, okay, and not the platform. So platform is given protection through section 79 of the Information Technology Act of 2000. What is this section 79 popularly termed as? It is termed as with the phrase safe harbor. Okay, right? This is what? The IT Act of 2000, right? So who is to be held liable? Only and only the user. When we talk about the key provisions as per section 79's provision, clause 1, exemption from liability, as in intermediaries shall not be held liable for content posted by users unless they are involved in modifying or creating the content. 79 clause 2, conditions for safe harbor protection, as in the intermediary must act as a passive conduit, as in that is they do not modify or curate the content. It should follow the provisions of the laws and IT rules. And clause 3, exceptions to the safe harbor protection. Are there any exceptions to it as well? So yes, there are exceptions to the safe harbor. That is, safe harbor does not apply if the intermediary is actively involved in publishing, modifying or even selecting the content. And second, the intermediary fails to remove the content after receiving actual knowledge by the government or any court order. So let's say safe harbor shall be not there, or this safe harbor shield shall be breached in case the intermediary is itself involving in promoting such content. In the case of group, okay, X was actively promoting it. And secondly, even if the court order has been issued, or even if the government order has also been issued to remove such content, and even after having the government order or the court order, still the intermediary is not eliminating or doing away or just deleting such posts, then the safe harbor shall not be given to the intermediary. Okay, I hope you guys are all able to understand. So what is safe harbor? The intermediaries should not be held liable for the content posted on their platform. What is exception to the safe harbors? If the intermediary is itself involved in promoting such type of content that is derogatory or spreading misinformation. Secondly, even if after the government's notice or the court's order, the intermediary is not taking any cognizant action in removing or deleting or vanishing or washing away such content, then also the safe harbor shall not be working and the intermediary shall be taken into the prosecution. Okay, so we have got some cases related to it, like for example the 2015 Shreya Singhal case. Okay, what happened into the Shreya Singhal case? If you go on to after the class, what you can do, if you just go into the video section, nearly 10 days back we uploaded a video related to this particular content, that is Shreya Singhal versus Union of India case of 2017. Okay, so in that we discussed about this intermediaries and everything. Okay, so what Shreya Singhal case of 2023 talked about? Okay, 2015 talked about. So the Supreme Court limited the scope of section 79 clause 3 subclause B, ruling that content removal orders must come from a court or government notification based on article 19 clause 2. Okay, based on what? Article 19 clause 2. And now what is article 19 clause 2? Okay, article 19 clause 2. It talks about reasonable restrictions. Reasonable restrictions to the rights guaranteed under Article 19 clause 1 subclause A. Simply, what is Article 19 clause 1 subclause A? It is freedom of speech and expression. Okay, so reasonable restrictions. Okay, what is reasonable restrictions? Guaranteed where? Under Article 19 clause 2. Reasonable restrictions on what? On freedom of speech and expressions, that is Article 19 clause 1 subclause A. Right. So this is where Supreme Court ruled into the Shreya Singhal case of 2015. Okay. Next, for that sake, government has also created the Sahyog portal. Okay, so the ministry involved, once again the MeitY, that is Ministry of Electronics and Information Technology, okay, came forward in October 2024 a portal that is Sahyog. Okay, Sahyog, where blocking of orders can be issued and uploaded by the authorities. Okay, blocking orders, it could be uploaded by the authorities, okay, related to any post, related to any particular act under under section 79 clause 3 subclause B. Okay, so what is Sahyog portal? Portal where blocking orders can be issued and uploaded by the authorities. Okay, when it came into being? October 2024. Working under which ministry? Once again, Ministry of Electronics and Information Technology, MeitY. Okay, next, the Hague Convention of 1965. What is this now? The US Securities and Exchange Commission just like we have got in India SEBI, okay, that is Security Exchange Board of India. Okay, so remember, Securities Exchange Board of India, okay, if it is SEBI is to India, okay, then SEC, Securities Exchange Committee, is to US, okay. So just like in India we have got Securities Exchange Board of India, okay, America we have got their Securities and Exchange Commission, which has sought assistance from the Indian government under the Hague Service Convention of 1965 to serve summons to Gautam Adani, okay, in a securities and wire fraud case, okay. So Gautam Adani was called by the US judiciary, by the US government even, for the sake of some proceedings or for the sake of some inquiry, basically not proceedings, generally inquiry related to some anomalies or discrepancies related to the securities, that is basically the stocks or debentures of some American companies, okay. Now since the point is Gautam Adani is an Indian citizen, firstly, right, can such type of orders by a foreign government be issued against an Indian citizen or any other citizen? Yes, that is possible. We have got an act for this, that is known as the Hague Service Commission, okay, 1965, an act that is globally accepted act. What is the name? Hague Service Commission, okay. Signed in which year? Signed in the year 1965. And what are the features to it? Okay, what are the segments to it? Okay, so here we go. The first and foremost thing, it is the legal treaty signed by 84 countries, including India and America. Firstly, so we have signed the Hague Service Commission. Formerly, it was known as Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters. So, a long name converted to the short one, Hague Service Commission. Okay. The treaty ensures that people in one country can be served legal documents properly when they are involved in court cases in any another country. What is the goal to it? The main goal is to ensure that people receive timely and fair notice of legal proceedings against them. Okay, in case there is a citizen of country X and against this citizen of country X, a particular another country is there of country Y, that is country Y, and in that country Y against the citizen of country X, a case is going on. So that country Y can send the legal notices, documents related to the case, okay, of the citizen of country X, okay, and the country X will have to comply with the legal documents as well as the notices and summons issued, okay. So this is where the Hague Service Commission comes into the picture, okay. So how does it work? Each country in the treaty appoints a central authority to handle legal documents requests. The country requesting legal services must follow the rules of the receiving country. And secondly, the legal documents can be sent through only designated authorities or postal services or diplomatic channels or other approved methods. It's not like that WhatsApp kar diya hai, dekh lena. No. Okay. It's not like I have sent you on your WhatsApp or on your social media. No, not like that. Okay, it should be either through the designated authorities like ambassadors, okay, consulate generals, etc. Postal services should be sent properly through post or through other diplomatic channels or any other approved methods that is approved between both the countries. Okay. Then next, what is India's stand on the Hague Service Commission? Are we part of it? Yes. Okay, we are part of it. As we can see, we joined the Hague Service Commission when? In the year 2006, but has placed restrictions on how the legal notices shall be served. So literally speaking, have we joined the Hague Service Commission? Yes or no? Yes, we have joined. Did we join it since its inception? No. So as we can see, it came into being only in the year 1965 and we joined in the year 2006. So after 41 years, okay, of this commission, we joined it. Okay, that is only in the year 2006. And which ministry is responsible for handling this? So it is once again the Ministry of Law and Justice. I guess it was the second topic of the day for us today when we discussed about the Department of Justice working under what? Ministry of Law related to e-courts. So the very same Ministry of Law and Justice shall be taking care of it. Okay. So next, very recently, okay, we have witnessed a particular report. It is known as India Justice Report. Okay, very recently, very freshly we have got this. Okay, known as what? The India Justice Report. Okay. As per the India Justice Report and as per the other organizations as well, including the National Crime Records Bureau, out of every 100, 70 prisoners in the Indian prisons, basically in the Indian jails, they are the under trials. Who are they? They are under trials, as in on whom just the case has been registered, as in they are just right now accused. They are not the culprits, declared culprits yet. Okay, who are they? They are just accused. So out of 100, every 70 prisoners inside the Indian jails, who are they? They are literally the under trials. Okay. Now, as per the CRPC section 436, okay, and as per the BNS, Bharatiya Nyaya Sanhita's 439, okay, section 479 actually, okay, what we can see, it is talking about the release of the prisoners, that is providing the bail to the prisoners. Okay. Now, as per the Supreme Court's rulings, okay, as per the rulings of whom? As per the rulings of Supreme Court, what has been mentioned? Bail is right, arrest is exception. Okay, bail is what? The right of each and every prisoner. Okay, specifically the prisoner, the one who is the under trial. Okay, so the one who is under trial, for him or her, bail is a fundamental right. Okay, so arrest of that person is an exception, but the bail is the fundamental right. Right, okay. So for that case, for that sense, what we have got, section 479 of the BNS, that is Bharatiya Nyaya Sanhita, that talks about the eligibility of the release. So as we can see, as per the eligibility of the release, few conditions they have been kept. Like for example, the first time offenders. So if there is a person who is a first time offender, okay, so eligible for release on bond, but when? After serving 1/3 of their maximum potential sentence. Okay, if they have served 1/3 of their maximum potential sentence. So let's say for example, if the crime they have committed, which is right now yet to be proven, so that possess 10 years of imprisonment. So if they are there into the prison since 3 years, okay, so it can be given. Okay, so the bail shall be now given immediately. Next, under trial prisoners. Okay, the under trial prisoners eligible for bail after serving half of their maximum potential sentence. Okay, if they are the repeated offenders but still under trial. Okay, so let's say 10 years of the sentence would be granted after the trial has been completed. So if they have completed 5 years of their sentence, then also they can be given the bail. Okay, so role of the prison authorities. What shall be the role of the prison authorities here? So, okay, what we can see, the prison superintendents must file applications within the courts for the release of eligible prisoners. And this comes into the picture because of this particular data. So this data is given by the NCRB and it was also published in the India Justice Report. What you can see, the statistics in India, this is about 2022, and what the data is telling us. Nearly 5,73,220 people incarcerated as in taken into the prison. Okay. 4,34,302, that is the exact data, 75.8%, they are under trials. That means against whom just the case has been registered, as in the trials are going on. They are yet to be certified whether they are the culprits or not. So, under trials. Okay, how many of them out of 5,73,220 people in 2022? 4,34,302, they are what? The under trials. So specifically the data is 75.8%. Okay, so there comes into the list section 479 of the BNS, that is Bharatiya Nyay Sanhita. Okay, next. The pay commission, obviously, which is loved by each and every employee, from the private to public. Okay, pay commission is something which is loved by everyone. Okay, so guys, before we start the next chapter, this next point of discussion, I think a short break of 10 minutes can be taken. Okay, since we are here into the class since around 2 hours. Okay, so a short break of 10 minutes can be taken, as let's go and have grab some glass of water and a cup of coffee as well, and then let's be back. So guys, before we start, okay, so we are going on a short break of not more than 10 minutes. Okay. Okay guys, so I'll see you all sharply in exactly 10 minutes. Okay, see ya. Okay guys, so welcome back. So we are good to start, right? So here we go. The next topic, the pay commission. What is the pay commission, right? So the constitution of the 8th pay commission has been done now. Okay, so as you can see, which has been approved by the union government to address the long-standing demands of employees and trade unions for upgradation in their wage and pensions. Okay, so about the pay commission. So first of all, it is established by whom? By the central government only, to review and recommend changes to the salary, allowances, pension structures of the central government employees, okay, as well as those who have retired now and on pension. So what will be the composition? So it shall be having the Department of Expenditure from the Ministry of Finance. Okay, simply speaking, the whole Department of Expenditure coming from where? Coming from Ministry of Finance shall be there inside the pay commission. And we talk about the previous pay commissions. So since 1947, okay, till date 2025, 7 pay commissions have been constituted. Okay, and the 7th one, that is the most recent one, it was in the year 2016, which shall continue till 2026. So the 8th pay commission shall come only into the existence in 2026. Okay, and who is the present chief of the pay commission? It is Justice Ashok Kumar Mathur. So you can just have the name, though the names are not much asked inside the UPSC prelims, but still for the sake of reference, if you can remember, you can just keep it. Okay, so here we go to the next one, rarest of rare doctrine. Okay, what is this rarest of rare doctrine? The most important thing here with regard to the case that happened, that is popularly we call it as the Nirbhaya case, 16th December 2012, 13 years, almost 13 years back from here. It was exactly February 2013 when central government constituted Justice Verma Committee. Okay, central government constituted what? Justice Verma Committee. Okay, to look forward the eligibility of this particular segment that is known as rarest of rare case. Okay, so from 2013 onwards, this rarest of rare doctrine was applicable inside the rape cases of India. Okay, rape cases that are happening in India, but the history goes way beyond than this. Okay, the Supreme Court in the Bachchan Singh versus State of Punjab of 1980. Okay, when it came, Bachchan Singh versus State of Punjab, guys, case reference is very, very important. Right, so Bachchan Singh versus State of Punjab 1980 established the principle that the death penalty should only be imposed in the rarest of rare case. Okay, and Justice Verma Committee provided that each and every rape shall be taken as rarest of rare. And now this time it is about CBI's demand. Okay, this time it is about CBI's demand into the Arjikar Medical Hospital case. July 2024, last year, what we have witnessed, one of the most brutal cases ever. Okay, the rape that shocked and shooked the whole nation, shocked and shooked both simultaneously the whole nation. One accused was taken into the custody named as Sanjay Roy. Okay, and as per the Calcutta District Court, as per the District Court sentence, okay, the Sanjay Roy was given the life imprisonment. Okay, Sanjay Roy was given the award of life imprisonment, for which the CBI has appealed to the higher court demanding death penalty for Sanjay Roy, talking about simply the condition where it shall be taken as the rarest of rare. Okay, so remember the case references. Okay, so we have got multiple case references, as in the Sanjay Roy's case, or the Bachchan Singh versus the state of Punjab case, and apart from that Ram Naresh and others versus the state of Chhattisgarh. And yes, apart from that we have got one more case, Machhe Singh versus the state of Punjab, 1983. But yes, the most important thing, okay, if you are not able to recall everyone, but so starting with the Bachchan Singh case of 1980, crossing through the Justice Verma Committee report of 2013, and yes, then coming finally to the RG Kar Medical Hospital case of 2024. Okay. So here comes the next one, abetment of suicide. Abetment, what do you mean by the term abetment? Provoking someone. Okay. Abatement as in simply meaning provoking, as in motivating someone for doing an act, for performing an activity. Okay, so this is what abatement of suicide. So what is the context? The Supreme Court has emphasized the need to sensitize investigating agencies and courts regarding abatement of suicide cases under section 306 of the erstwhile IPC to prevent misuse of the legal provisions. Okay, and now what section 107 says? This is similar to section 45 of BNS, that is presently Bharatiya Nyaya Sanhita. It defines abatement as instigating someone to do a thing, engaging in a conspiracy to do a thing, or intentionally aiding the act or illegal omission. Okay, that is hiding something. So this is what all as per the BNS section 45, IPC section 107 as well as section 306. Okay, that talks about the punishment when it comes to the abatement of suicides. Okay, and what Supreme Court has ruled. Okay, Supreme Court has made the illustrative criteria for assessing cases of abatement of suicide. Like for example, the first one, unbearable harassment. Second, exploitation of vulnerability, as in whether the accused exploited the emotional vulnerability of the deceased. Simply emotional exploitation. Then threats and intimidation. And lastly, false allegations. So these are 4 criteria given by the Honorable Supreme Court to be taken as the criteria or to be taken as the features of abatement of suicide. So what is that? Harassment, simply unbearable harassment. Then emotional exploitation. Okay. Apart from that, yes, threats and intimidation, that is warning someone or threatening someone. And lastly, yes, having false allegations on someone. Okay. So the case references are here as well. M. Mohan versus the state, that is 2011, and Uday Singh versus state of Haryana, 2019. Okay, though not very much in trend, but yes, you can have the references, okay, if you can remember, or else not to worry. Next, electoral bond versus electoral trust. What we have seen, after the discontinuation of electoral bonds, electoral trusts, they have been now came into the vagueness. They have become vogue. Okay, that is the very trendy thing here into the political dimensions of our country. So as we can see, after the Supreme Court ban on electoral bonds, donation to political parties saw a surge, a significant increase through electoral trusts. Okay, now what are these electoral trusts? Okay, so if we just go ahead directly to the differences between electoral bonds and electoral trusts. So here we go. As we talk about on electoral trusts and electoral bonds, here it offers transparency, as in public can see who is funding whom. Electoral bonds, lack of transparency. Only the aggregate amount received is reported to the Election Commission of India and no one will see who donated to whom. Then as per the electoral trusts, Contributors identifies are public, though tracing specific donations can be challenging in cases of multiple contributors. Okay. Provide, as per the bonds, complete anonymity to donors, shielding their identities. Okay, so here identity is visible, here identity is not visible. Then once again the trust. Most must submit annual contribution reports to ECI. Okay, here parties report only the total donation received through bonds. Then here, donation patterns. Varied donation patterns. Some trusts, like prudent electoral trusts, donate significant amount to the multiple parties, whereas here less transparent due to the donor anonymity, as in no identity, so obviously it will become anonymous, right? So after the Supreme Court banned the concept of electoral bonds couple of years back, 2 years back exactly, now what we have seen, a surge, a high level of surge or significant level of growth in the electoral trusts. Okay, so the difference between the trust and the bond, it is already clear. So right now the bonds are gone, the trusts are active. Next comes into the list here, the appointment of ad hoc judges. Okay, what is this? The appointment of ad hoc judges. So when we talk about simply the ad hoc judges, so what do we mean by the term ad hoc? As in temporary. Ad hoc simply means temporary. Okay, temporary. So as per the Constitution articles, so we talk about Article 224 capital A for High Courts and Article 127, okay, for Supreme Courts. All the retired judges, okay, can be called once again to serve as temporary judges. Okay, under Article 224 capital A for the High Courts and 127 for Supreme Courts. Okay, the retired judges can be called for the appointment or can be called for the service once again for a temporary period of time, okay, inside the Supreme Court as well as High Courts. Okay, so when you talk about specifically here Article 224 capital A, right, so when it came into being, it was inserted through the 15th Constitutional Amendment Act of 1963. Okay, and we talk about the other provisions. So retirement age, the retirement age for High Court judges was increased from 60 to 62 years through this very same amendment. Okay, and writs, High Courts could issue writs to people or authorities outside their territorial jurisdiction if the cause of action was within their jurisdiction as per Article 226 clause 2. Simply speaking here, when we talk about the jurisdictions of High Courts, so in one type we have got the writ jurisdiction. Writ jurisdiction as in justified under Article 226. For Supreme Court it is Article 32. So once again the same writs, habeas corpus, certiorari, written as certiorari but pronounced as certiorari, quo warranto, mandamus and prohibition. Okay, so these are the 5 types of writs that are given to High Courts under Article 226 as well as to Supreme Courts under Article 32. Okay, now the writ jurisdiction, of High Courts are High Court is wider than that of Supreme Court. Why? Okay, why or how? Why? Because Supreme Court can issue writs only for part 3, that is fundamental rights, whereas high courts can issue writs for fundamental rights as well as other provisions or other rights as well. So that is why the writ jurisdiction of High Court is considered wider than that of Supreme Court. And now when we talk about Article 226 Clause 2, what it is saying? The High Courts can issue writs, the High Courts can issue writs outside their jurisdiction in a condition. And what is the condition mentioned? Okay, so high courts could issue writs to people or authorities outside their territorial jurisdiction if the cause of action was within their jurisdiction. If the action or the crime etc. happened within the territorial jurisdiction of High Court, within territorial jurisdiction of High Court. Okay, so this is what Supreme Court has stated, right? Or this is what Constitution has stated. Okay, and yes, remember always the ad hoc judges can be there. Okay, ad hoc judges under Article 224 capital A for High Courts and 127 for the Supreme Court in India. Who can appoint? Obviously the President after the due this delegation, okay, or discussion with the Chief Justice of India, concerned law ministry as well as the state government. Okay, next, the blood money, very much in trend. What is this now? The blood money. The death sentence awarded by the context, first of all, from where this context of blood money has been coming. Okay, the death sentence awarded by a Yemen court to a nurse from Kerala for murdering her business partner. Okay, for murdering her business partner, and the subsequent debates and efforts surrounding her acquittal and repatriation have brought the focus back on blood money and its implications. Right, so here is the context. Now what is blood money? How do I justify this term blood money? It is known as diya in the Islamic Sharia law. So it's the diya, okay, it's the Arabic word. Okay, it involves compensation paid by the perpetrator of a crime to the victim of their family. As in, if there is a criminal who has murdered an individual, so as part of justice, as per the Sharia law, as part of justice, as per the Sharia law, that particular perpetrator or the criminal will pay a fixed certain or sum of money to the family of the victim, to the kin and kin of the victim. Okay, this is what known as blood money as per the Sharia law, and in Sharia it is phrased as diya, D-I-Y-A. What is the purpose? Obviously to alleviate the suffering of the victim's family. Okay. So here we go. We have got the blood money as per the Indian laws, not talking about specifically Sharia, but do we have the concept of blood money as when it comes to the Indian laws? So here we go. No direct provision for blood money in India's legal system. Okay, the first line, what it is saying, no direct provision, okay, of what? Of blood money in India's legal systems. Okay, Now, comparable concept. There is nothing known as blood money, but there is something related to blood money. What is that? That is known as plea bargaining. Okay, it is not exactly blood money, but related to something blood money, known as what? Plea bargaining, introduced via the Criminal Law Amendment Act of 2005. And what it says, it allows the defendants to plead guilty for lesser charges or reduced sentences in return for concessions. For example, if there is a culprit who has been awarded a sentence of 10 years. So, if the culprit provides some compensation to the victim's family, then his or her award, that is his or her sentence, could be reduced. Could be. Okay, there is nothing guaranteed, but could be. So, this is what is known as plea bargaining. So, limitations of plea bargaining, what it is? Applies only to offences with imprisonment less than 7 years. Firstly. Secondly, not applicable for crimes against women, children, and heinous crimes or socio-economic offences. And third, victims may receive compensation under section 265 capital E of the IPC, okay, of the Indian Penal Code, specifically through the Criminal Law Amendment Act of 2005. So remember, firstly, plea bargaining's eligibility or its applicability. Applicability is here when the crime is having a sentence of less than 7 years. Secondly, if it is a crime against women, no scope of plea bargaining. If it is against children, no scope. If it is a very heinous crime or related to socio-economic offences, then also no scope of any sort of plea bargaining. And lastly, victims may receive compensation, okay, under which section? Section 265 capital E of what? Of the IPC, coming from the Criminal Law Amendment Act of 2005. Okay. So here we have next one, the Dam Safety Act of 2021. Okay. What we have? The Dam Safety Act of 2021. So, the Supreme Court criticized the Union government for its delay in implementing the Dam Safety Act of 2021. And what is the key concerns in front of the Supreme Court? Okay, what Supreme Court has raised, the alarm raised by Supreme Court. It delayed implementation. Okay, first one, the delayed implementation. So, the Act mandates the creation of National Committee on Dam Safety within 60 days of its commencement. Okay, the committee, which must be reconstituted every 3 years, has not yet been formed. Okay, even after 4 years of the commencement of the Dam Safety Act, no Dam Safety Committee has been established. As per the norms of the Dam Safety Act, within 60 days of the commencement of the Act, a Dam Safety Committee was to be constituted, which should be renewed in every 3 years. But even after 4 years of the commencement of the Act, no such committee has been established. Then, the biggest concern, the biggest alarm which was raised by judiciary, specifically Supreme Court talking about, was the Mulla Periyar Dam. Okay. So, structures like Mulla Periyar Dam, which was built in 1895 using limestone and surkhi, are vulnerable to structural failures, and this is great cause of concern, great cause of concern, right. So, Mulla Periyar Dam, as you can see, it's almost 140 years old, which is made with just limestone and some surkhis. Okay, and now this is huge concern. So, for that, the Dam Safety Act came into being in 2021, but still even present date, no such committee has been made. Okay. Okay, here we go. New rules for Aadhaar authentication. Okay, UIDAI. So, UIDAI, what is the full form? Unique U for unique identity authority of India. Okay. Working under which ministry? Obviously, once again, MeitY, as in the beginning of the session only I told. This is the particular ministry which will be in news multiple times. Okay. What is MeitY? Ministry of Electronics and Information Technology. It has notified amendments to the Aadhaar, Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act 2016. Okay. So, as per the amendments, there shall be some new process, as in expanded scope of Aadhaar authentication. As in, the amendment broadens the use of Aadhaar card or simply the Aadhaar authentication to include both government and non-governmental entities. Okay, for the sake of good governance, social welfare programs, innovations, knowledge, dissemination and ease of living. And these changes will improve service delivery. So, as specifically when we talk about the delivery of social welfare programs, okay, it shall be boosted or provided with much more silky functioning of the service delivery functions, not only in the government but also in the non-governmental, that is private entities. So, for which Aadhaar authentication is now given to not just the government but also to the private companies. So, this is what the amendment. So, nothing much to be discussed here. Okay. So, Aircrafts Objects Bill, as I stated, until and unless the bill has been converted into the act, you need not worry about the bill. You need to worry about the bill only when it is converted into the act. But yes, with this bill, another event has come into the news, that is known as CTC. No, this is not cost to company. It is Cape Town Convention. When it came to existence, 2001. What it is? An international treaty that standardizes transactions involving, first, movable property such as aircraft, its engines and the helicopters. Second, legal protection for creditors, financiers and the lessors. And third, rules for asset recovery during airline defaults or insolvency. Okay, so this is what is known as Cape Town Convention of 2001. Is India party to it? Yes, we have signed it in the year 2008, but we haven't ratified it. Right now, it is not ratified by the Indian Parliament. So, Indian Parliament is yet to ratify it. We have signed in 2008. But remember, not yet ratified. Okay. So, party but not we are active there, right? So, this is the features of the bill. You can skip this part. Nothing much to worry in this. Okay. Coming to the next one. EVM verification. Okay. Here's the next one. That is EVM, electronic voting machine verification. What is that? The Supreme Court of India asked the Election Commission of India to ensure that polling data is not deleted from the electronic voting machine while they are being verified. Okay. So, there are many instances where people they have claimed and blamed that their EVM was hacked. Their EVM was not functioning as per. And hence, as a result, it should be taken into the scrutiny. So, what Supreme Court has stated to the Election Commission of India that until and unless, the EVMs, they are taken into the scrutiny and the proper review of whether they are being hacked or not has been done, the data should not be erased. Okay, they should not be erased. So, about Supreme Court's direction, no erasing or reloading of data. The court directed the Election Commission of India not to erase or reload the polling data during the verification. First thing. Second, clarification on verification process. The burnt memory which is there into the microcontroller should be checked in the presence of the requesting candidate. Whosoever has requested to check or scrutinize the EVM, okay, the burnt memory or simply the microcontroller should be checked in the presence of that candidate. Second, engineers from the EVM manufacturers must certify that no tampering has been occurred. Okay, so certification from the engineers is also required, and those engineers should also be coming from or only be coming from the certified manufacturers. Okay, now when you talk about the verification process, okay, there is a process and it is very, very important process, guys. Please make a clear hold and clear note of it. Okay, first, the candidates eligible for verification. Who is eligible for applying for the verification or scrutiny of EVM? Only candidate who scored second or third place in the election, okay, can apply. Not the one who scored fourth, fifth, sixth position. No, only the one, those who scored the second and third place. Okay. Next, scope of verification. 5% of the EVMs per assembly segment can be checked. Not all of them. Out of 100, only 5 of them can be checked. Okay. Next, application process. Candidates must submit a written request within 7 days of such pollings or of such results declaration, not polling, sorry. 7 days after the results have been declared. So let's say today the results have been declared. Today it is 17th of May. So 7 days from here, that is by 24th of May, the results should be declared. The candidate must file the petition, written petition to scrutinize or verify the EVMs. Okay. Next, responsible authority. Who is to be responsible, okay, for such verification? So it will be the DEO, that is the District Election Officer, in coordination with engineers. Okay. And last, cost and refund. Candidates must bear the cost of verification. So if you are the candidate applying for verification, okay, then you will pay for the verification cost, but they will be refunded if the tampering is found. Okay, so if there will be any sort of tampering found, they will be refunded, but in case the engineers certified along with the district election officer that no tampering was there, then there will be no scope of any sort of refund. Okay, so 7 days from the date of declaration of results, eligible candidates, second and third rank holders into the list. Okay, and yes, refund. No refund in case no tampering has been found, and all refund in case tampering was there. Corruption Perception Index. Next, thankfully we have performed well. Transparency International. There is a non-governmental organization, an international organization as well, that is known as Transparency International. It released its annual Corruption Perception Index, that is CPI. Okay. As per the 2024, okay, as per the 2024, India has performed better into the Corruption Perception Index. Okay, so if we see firstly about the CPI, the global average score remains 43, that is unchanged. More than 2/3 of the countries scored below 50, indicating widespread corruption. And India ranked 96th out of 180 with a score of 38, a decline of 1 point from the previous year. Okay, so we were 39 last year and this year we are 38. So how CPI measures? Okay, as you can see, 180 countries, okay, based on the perceived corruption in the public sector, and the score is calculated on a scale of 0 to 100. 0 that is highly corrupt and 100 that is very clean. What is India's rank? Okay, 96 and the score is 38. Okay. So it uses 13 data resources including reports from World Bank, World Economic Forum and other private risk consulting firms. Okay. So what is our present rank as per the 2024 report given to us in 25? As per the present rank 96, score 38. Okay, the top 5 least corrupt countries, okay, with the highest score as in Denmark 1, Finland 2, Singapore 3 and New Zealand 4. We talk about bottom 5. Okay, South Sudan, Somalia, Venezuela and Syria. Right? So, talking about Transparency International, what it is? A global non-governmental organization. Remember, it is non-governmental, not related to UN, World Bank, IMF. It just takes the reports of World Bank, World Economic Forum and so on. It is non-governmental totally. Okay. So, it is giving the reports since when? Since 1995. So, almost, not almost, exactly it is now 30 years for them in providing the reports. Okay. What is the name? Transparency International. Okay. Just like if you have heard about this Amnesty International, in that very same sense we have got Transparency International. Okay, so here we go to the next topic, the living will. Recently, the Government Medical College Hospital Kollam in Kerala established a living will information counter. Okay, what is that? Living will information counter. It is the first hospital in India to set up such a counter to popularize the concept of living will. Where? Kerala, the government hospital in the Kollam district of Kerala. Now, what is this living will first of all? How am I going to justify the term living will? Okay, so a living will is a legal document that records an individual's preferences for medical treatment in situation where they are unable to communicate their wishes due to the terminal illness or life-threatening condition. Simply, if the particular person has gone into a state, we talk about vegetative state. Okay, in medical terms, it is known as vegetative state, where the person is alive but with no senses. Okay, so in that case, the person can represent his or her living will, okay, to go ahead with the medical treatment. Okay, so writing a living will requires the involvement of 2 or more healthcare attorneys, gazetted officer or a notary, and 2 witnesses. Okay, then only living will shall be considered certified. Okay, and living will is what? Whether I am ready to live and have the treatment or whether I am not and wants the euthanasia. Okay, euthanasia as in is known as the Ichha Mrityu in Hindi. Okay, now what is the difference between euthanasia and living will? So, living will, first of all, it is legal in India. We talk about legal status. And euthanasia, active euthanasia is illegal, only passive euthanasia is allowed as per the cases. Cases as in, for example, we have got the Arunima Shanbog case. For the reference you can keep Arunima Shanbog case of 2011. Okay, Arunima Shanbog case of 2011, and one more we have got Jian Kaur case of 1996. Okay, so these are the 2 cases related to the euthanasia in India. Okay, Arunima Shanbog and Jian Kaur case. Okay, Arunima Shanbog, she was a nurse into a hospital in Mumbai, and she was brutally assaulted by one of her colleague, and in that assault she somehow, the oxygen supply to her brain got disconnected, and because of which she went into the vegetative state. Though she lived from 1973, she died only in the year 2025. Oh, sorry, 2015. So she lived her life around, when she died, she was around 66 years of age. But for 40 years plus, she was in vegetative state. So in 2011, a petitioner filed a petition in front of the Supreme Court to provide euthanasia, passive euthanasia to Arunima Shanbhog. But she died her natural death only at the age of around 66. She suffered from pneumonia badly. She was affected by pneumonia by the time, and so she died because of the pneumonia, not because of euthanasia. Okay, so in that case, in the Arunima Shanbhog case only, Supreme Court justified that active euthanasia is not legal in India, but yes, passive euthanasia is legal. Okay, only when the patient is considered medically dead. Okay, medically dead but alive. Medical dead is that vegetative state. Okay, where all the body senses are now over, just the heart is beating. Okay, so is it legal in India? There are two types of euthanasias, active and passive. So active is not legal, but yes, passive is legal. Case reference, please remember two cases, Jian Kaur case of 1996 and Arunima Shanbhog case of 2011. Okay, now the definition. A living will. It is a legal document specifying a person's medical treatment preferences if they become incapacitated. Okay, and second, the act of intentionally ending a person's life to relieve from suffering. Talk about the effectiveness. Comes into effect when the person is incapacitated but alive. That is type of into the vegetative state again. Here, requires external intervention to cause death. And then outcomes. Does not lead to death but only ensures personal choice in treatment. And this leads to the death of the patient. Okay, that is known as mercy killing type of, it is known as mercy killing. Euthanasia also it is termed as mercy killing. Okay, so next, devolution index ranking of Panchayati Raj system. So when it comes to the devolution or decentralization of powers with regard to panchayats in India, it is the top three states, Karnataka, okay, Kerala and Tamil Nadu. They are performing the best. Karnataka with a score of 72.23, Kerala with a score of 20.59 and Tamil Nadu with a score of 68.38. Okay, so context, as we can see, Karnataka has topped the overall devolution index ranking of the Panchayati Raj system among the states. Okay, who has topped? It is Karnataka, followed by Kerala and Tamil Nadu. Okay, so as we can see about the devolution index, what is the purpose? The report ranks Indian states and UTs based on their devolution, that is transfer of power and resources to the Panchayati Raj institutions. Okay, how much powers and resources they are being transferred to the panchayats. Who prepares it? It is the Ministry of Panchayati Raj along with Indian Institute of Public Administration based in New Delhi. Okay, so these are the two organizations that prepares what? The devolution index. Okay, and which state has topped? It is once again Karnataka, followed by Kerala and Tamil Nadu. Okay, that's it, not much here to worry about. Okay, the Immigration and Foreigners Bill 2025. So as I stated, if it is a bill, okay, it is not much worrisome thing for you. You can skip this one here. But yes, there are few provisions that we need to discuss. Evolution of India's immigration laws. How immigration laws evolved in India. So the first one, the Passport Entry into India Act 1920. Second, the Registration of Foreigners Act 1939. As we discussed about that Foreigners Tribunal, right? So we have got the Foreigners Act 1946, through which we have established the Foreigners Tribunal in 1924 exclusively in Assam. Okay, then the Foreigners Act once again 1976, and the latest one, the Immigration Careers Liability Act 2000. Okay, so these are all what? The immigration laws, immigration related laws in India. And remember guys, This is the bill. Okay, you need not worry about the bill. Okay, until and unless it becomes an act. Okay. So here we go. The next one. Supreme Court's directions on remissions. Okay. Supreme Court's directives on remission. What is remission? Type of a pardon given to a culprit. Okay, so here we go. Recently, the Supreme Court ruled that appropriate governments must proactively consider the premature release of eligible convicts under the remission policies. So, when we talk about remission, okay, Article 72, okay, we have got Article 72 that provides what? The pardoning power to President. So, as per Article 72, President has got the following pardoning powers. So, first is total pardon. Okay, relieving the convict from all the sentences, from all the punishments. Okay, then respite. Then one is got, we have got remission. Okay, and the one is stay on execution. Okay, as in reprieve. Okay, so these are the types of pardoning powers available to the president. Okay, same powers they are also given to the governors of the states, but here right now we are discussing president under Article 72, governors 165. Okay, so what is this concept here? Key directives from the Supreme Court's judgment. Mandatory consideration of premature release. Okay, remission as in decreasing the sentence. Okay, decreasing the punishment of the convict. Okay, so if the government has policy under section 432 of the CRPC or section 473 of the Bharatiya Nyaya Sanhita, it must consider all eligible convicts for premature release. Okay, before providing any sort of this release or any sort of remission. What are the things that are to be kept? Okay, it is section 432 of CRPC and section 473 of the BNS, Bharatiya Nyaya Sanhita. Okay, and it should be also taking into the consideration the cases, like for example, we have got the Mafa Bhai Moti Bhai Sagar versus state of Gujarat and state of Haryana versus Mahendra Singh and others. Guys, very, very important. Please make it clear. Okay, the case references Mafa Bhai Moti Bhai Sagar versus state of Gujarat and state of Haryana versus Mahendra Singh and others, 2007. Okay, this is where the cases came into being through remission. Okay, that's it. Next and the most important one as well, Article 101 Clause 4. In Punjab, we have got a location somewhere, near Amritsar. It's known as Khadur Sahib. So, there is an elected member of parliament there. His name is Amritpal Singh, the one who is in jail since 2023. But he is now elected MP. So, what is the context here? Khadur Sahib MP Amritpal Singh, who has been detained under the NSA, National Security Act, since 2023, has moved the Punjab and Haryana High Court seeking permission to attend the ongoing parliamentary session. Okay, it was a time period during the budget session actually. Okay, when he applied. So, about Article 101 Clause 4, what it says. If for a period of 60 days, a member of either House of Parliament is without permission of the House, absent from all the meetings thereof, the House may declare his seat as vacant. As in, if for continuous, how many days? 60 days. an MP is not attending the parliamentary session, then Parliament can consider his seat to be declared vacant. Okay. However, the 60-day period does not include the two things. First, any time when Parliament is prorogued, that is not in session. And second, any time when Parliament is adjourned for more than 4 consecutive days. Okay. So, in the both conditions, the 60-day calculation is not done. But yes, the 60-day absence is counted only for actual sittings of the Parliament and not when the Parliament is in session, is not in session, that is in recess. Okay. And yes, the most important thing that is to be noted, even if an MP crosses the 60-day absence limit, his seat will not be automatically vacated. What will happen? The House must formally vote to declare his seat vacant, and then only the particular seat shall be declared vacant. Okay. So, process for seeking leave. Is there any process for seeking leave? Yes, there is a process. What it is? Article 101 clause 4 allows MPs to seek permission from the House for a prolonged absence. MPs must submit a request to the Committee on Absence of Members from the sitting of the House, which reviews the leave petition or the application, and second, recommends approval or rejection to the House. And it has been happened in 2023 when the Bahujan Samajwadi Party MP Atul Rai was granted leave for 23 consecutive sittings due to incarceration, as in when he was taken into the custody. Okay. So guys, this is it with regard to the today's topics. Any questions? Yes, hello guys, hello everyone, good evening now. Any questions guys you need to ask from the topics we discussed today or anything related to your subject, syllabus, strategy and so on? Any questions? Then go on, please tell me. Come on guys. No questions? No doubts? Okay. Okay guys, so we have got all the comprehensive discussion for today. Thank you so much for watching, and please remember, do not forget to subscribe to the StudyIQ IAS English channel. Okay, as you can see, the channel is providing you all of your required content. Okay guys, so thank you so much for watching. See you all soon in the next session now. Good day, take care. Do not forget to subscribe. Subscribing the channel is a must. Okay, and if you like this session, then do hit the like button as well. And if you have any opinion, any further things or any particular topic you want me to take on, so you can let me know into the comment section. Okay, so surely it shall be taken into the consideration quite soon. Okay guys, so good day. See you soon in the very next session. Bye bye. Take care. Jai Hind and Jai Bharat.